afternoon, sir. This is Vamika. Yeah. Nice to have you here today.
Hi, Vamika. Am I audible?
Yes, sir. You're audible.
I'll put my video on, but in case I'm getting stuck or something, I'll put the video off again in case of.
Sure. Yeah, your video and audio both are clear.
Right.
Yeah. Cool. So, yeah. Shreya, you can give a brief introduction about sir, and we can start from there.
I think Shreya is on mute actually.
Yes. Am I audible?
Yeah, right.
Yeah. Cool.
Okay. Very good afternoon to one and all, and welcome back to RSD 2021, the annual research of IIT Madras. Right now we have Mr. Tarun Khurana, who will be speaking about careers in patenting. He is the co-founding partner and patent attorney of Khurana and Khurana, an IP asset management firm, IIPRD, both of which are among leading companies in India and also have regional offices in many other countries. He is among the top 12 patent prosecution practitioners in India as ranked by IIM 1000 and also by IIM 300 strategist. He has a bachelor's in computer science engineering from Pune University, a master's in software systems from Abid Pilani, bachelor's in law and MBA from IIM Lucknow, and is in pursuit of his PhD. He is also a regular speaker at NTPC, Indian Oil, Unilever, IITs, IIM Lucknow, Mahindra, ONGC, and various others. A very warm welcome, and I would like to hand it over to you, sir.
All right. So should we wait for a few more minutes for other people to join in, or is it is everybody already in the call?
Sir, yeah, actually on the Zoom call, only the organizing team members are there. People will be watching this from YouTube.
All right. So should we start?
Yeah. Yes, sir.
So I would prefer to talk for about 35 minutes or so, 30, 35, maybe 40 minutes, depending on how the flow goes. And then more interested in answering questions. I unfortunately have a hard stop at 2:50. I have a cross-examination that has to start at 3 o'clock. So my apologies for that. But thank you very much for having me on board. And it's a pleasure to speak in front of such a learned audience. And I mean, IIT Madras needs no introduction. And it's a fantastic opportunity. And thank you very much for considering me worth enough for talking on this issue. It's actually a non-technical issue for a technical patent attorney like me. So fortunately, it's a change to talk on an aspect or a topic of this nature, where we usually otherwise talk about litigation issues and very core computer science or pharmaceutical or various other patent core technology issues in terms of how they've been infringing, or issues of freedom to operate, or other characteristic issues of patents. However, it's a good change to talk on a topic of this nature. Now, I think even before we get into careers and what intellectual property patent attorneys do, what patent attorneys do, it's important to have a very quick, brief background on what and is IP in general, and how are IPs different from, say, for example, intangible assets and maybe various other issues, right? So essentially, IP is nothing but a statutory right which is given to the creator of that particular work. There are various types of intellectual properties which are governed by TRIPS in general, which is the trade-related intellectual properties. And the TRIPS in general has a uniform harmonization done for multiple countries world over, indicative of what kind of rules and regulations they need to follow so as to be consistent with other countries and practices therein as to how IPs are regulated in each country. Now, for example, patents have a life of 20 years across the globe. Trademarks have to be renewed every 10 years across the globe. And likewise, there are certain fundamental aspects in terms of what grounds on which the patents are to be granted, what is substantive examination, how is it to be done. So there are certain aspects which are clearly laid out by the TRIPS, and that every country that is a member thereof or complying to thereof would have to apply for. So intellectual property in general is essentially a right which is given to an owner of that particular IP who's created that particular work, and is able to stop other third parties from making, using, selling, and offering to sell and importing that particular IP or patent or trademark or copyright, whatever the case might be. And I've given some examples on the kind of IPs that are there. There are trademarks that protect the brand names and the graphical representations which are associative of the companies. There are copyrights that protect the expressions in terms of creative expressions, in terms of books or sculptures or paintings or source code or computer programs and aspects of that nature. And then there are patents which are considered for technical inventions that have been done. And then there are designs which are called as industrial designs, which help you protect the shape of an article. So the beauty about IP essentially is that because you're working in a space where there are tons of new things being done, which are being done essentially by people who are called to be creative, or known to be, or expected to be creative. As an attorney or as a practitioner in this particular space, you get to interact with very smart talent world over, depending on what practice area you're in, depending on if you're in trademarks. But these are very, very heavy consequential aspects of law in terms of what kind of assets they are. Because I think if a company, if Daimler, for example, is Mercedes-Benz, and their logo gets compromised and gets some other company starts using it, the whole brand value of the company brings down. For companies like Nike, you can imagine how important that tick mark is for them. And therefore, intellectual properties with time to come, and even at this moment, for most industry verticals, form a significant portion of their attention, as well as contribution to their wealth in general.
Sir, sorry for interrupting. Can you please use slideshow mode and full screen?
Yeah. Is it better?
Yes, sir. Yeah, thank you.
So what is a patent? Once we've understood that there are different types of intellectual properties, how they are different from intangible assets, in terms of intangible assets essentially being, for example, a company like Infosys, essentially has a service vertical that has employs thousands and lakhs of software engineers to do different coding, but they don't own any of the IP that gets generated, because being a service company, all their IP gets owned by the clients that they work for essentially. So their intangible assets essentially are these people and professionals who have significant experience in coding and development across various platforms. And how those intangible assets are different from intellectual properties is by virtue of IP being protected by a particular statute. So patents are protected by a Patent Act, copyrights are protected by a Copyright Act, and so on and so forth. And that is how they become different and defendable and enforceable. Now, coming very quickly to patents, patents is nothing but an exclusive right for 20 years, which is given to an applicant to develop for an invention that he has done, and in exchange of a disclosure that he gives to the patent office. So an applicant or an inventor would typically file a patent application where it discloses what is the improvement that he has done over and above what was already out there. And then as a part of that, what kind of what is it trying to claim as part of the patent application? And that is what the inventor's core focus is in terms of obtaining the patent. So patent is granted, as I said, world over for 20 years from the date of filing of the application. And it could relate to a process, it could relate to a product, it could relate to a method of doing a certain action, could relate to a formulation, could relate to a machine, or in the context of a software, or in the context of a computer science background, it could essentially relate to a system that has a processor and has a memory, and the memory stores a set of instructions which, when executed by the processor, would enable certain actions to take place. So that is what patents would try and give you leverage of. And the system claim or the method claim in a software case, for example, would give you certain functionality over which you are getting the patent. And that needs to be drafted in the utmost correct manner, in view of the fact that there are certain aspects under Section 3 of the Patents Act which make certain subject matters non-statutory, which means that if you've developed a computer program or a software that is not a technical algorithm, or it doesn't solve a technical problem in context, it will be classified under Section 3K, and by virtue of being a software per se would not be granted. Similarly, if it's a method of doing agriculture, or if it's a new form of a known substance, all of them will be objected under Section 3D and others, which are mentioned under Section 3 in general. So patents essentially have certain prerequisites. They are territorial in nature, like most other IP. So you file it in India, you're only protected in India. You file it in the US, you're only protected in the US. So if a company like Microsoft has a patent in the US, but doesn't extend that to India in certain period of time that is allocated, then they would have no protection as regards India is concerned, which means that anybody in India can manufacture and sell that particular product, but cannot export it to the US because in the US it's a patented article. Hypothetical scenario. So essentially, the patent applications that are filed by different applicants are examined based on various parameters. Apart from Section 3, which talks about what is not patentable fundamentally, if you are not in any of those categories, then is when the controller or the examiner at the patent office would come down to these parameters for deciding on the fate of your application as to whether there is novelty in your invention and whether there is an inventive step there or not. And likewise, even for industrial applicability, which means that there has to be consistency of results that are coming out of the exercise of the execution of the patentable subject matter. Now, the aspect of the intent of the whole talk today was about careers in the patenting space, and therefore it's important for us to first of all understand what is the commercial relevance of a patent. Now, we do a lot of litigation in various high courts and district courts in India, where companies are trying to, for patents that they've obtained. For example, if a client has a patent on a particular machine that takes X as input and gives Y as output, the whole intent of getting the patent would be that nobody else is able to, in the country of protection, come up with a machine that does the same function on which you've got a patent. And therefore, the whole commercial incentive or the commercial basis of obtaining patents across various industrial areas, from automotive to mechanical to engineering to computer science to semiconductors, would essentially be that whatever you have a patent on essentially is enforced in a manner such that nobody else in the whole territory is able to commercialize it. And that is how companies like Gillette are so successful, because they come up with certain blade configurations or holder configurations that are so beautifully drafted as regards the patent application is concerned, that nobody else tomorrow is able to, for example, make a blade or a retractable blade or a detachable blade that has, say, 3 blades or more, or essentially are inclined at a certain angle such that the skin would never get cut, or whatever their claim essentially would be in terms of the orientation of the blades or the quality of blades or the material of construction or whatever that might be. All of these are responsibilities that we as patent professionals need to carry. And as far as the career of a patent professional is concerned, typically there's a very big demarcation of 2 types of careers that are available in the patent space. One is in the form of a patent prosecution attorney, and the other is in the form of a patent litigation attorney. And when I say patent prosecution, I essentially mean that attorneys that are involved in the life cycle of obtaining the patent, which means from the very beginning of conducting a prior art search to confirm whether there is novelty and inventive step, as I've mentioned here in the invention, and then going ahead to draft a strong patent application, to going ahead and filing it at the Indian Patent Office, to going ahead and complying with all the regulations in terms of Form 1, Form 2, Form 3, various formalities that are required for the filing of an application, compliance of the application to the requisite patent law, as well as then going ahead and filing international applications for the whole portfolio, where if an entity in India like Larsen and Toubro wishes to file an application in India and then eventually go out and file the same application and get it covered in the US and Europe. So the intent would be to use the same application filed in India, file a PCT application within 12 months from the Indian date, and then go into various countries of your interest. Or alternatively, without filing a PCT, directly file a Paris Convention application in these 2 countries. So the role of a patent prosecution attorney essentially will be from the filing of an application till the time the patent application is either granted or refused. And this would include not only drafting and responses to the examination reports that are issued, but also conducting searches, conducting freedom to operate searches that help you confirm whether upon commercialization of the product, would it infringe on somebody else's patent or not, and also do various other types of analytics or landscape exercises, understanding of patent portfolios, giving opinions on whether this is patentable or not, and etc. etc. The other whole different vertical on as regards a patent professional is concerned is with respect to a patent litigation attorney, where litigators essentially would try and either enforce or defend a particular patent infringement suit. And such patent litigation attorneys may not confine themselves only to patent cases, but also do IP cases in general, or even civil litigation in terms of NCLT disputes or commercial breach of contract or any other non-IP civil litigation, including property litigation if they wish to. However, there are few attorneys that do like specialization, and therefore they would either restrict themselves only to patent-based litigations, which are not very heavy or high in volume in India, or restrict themselves to IP-based litigations. Now, the role that most of the research scientists and research scholars that come out of various academic institutions that are technical in nature would focus mainly on patent prosecution as the role. Now, patent prosecution essentially can be done by two types of professionals. One is a qualified patent agent, who is essentially a professional who has cleared the patent bar exam, which is conducted by the Indian Patent Office. And then is able to then, as part of the registration or post the registration or qualification as a patent agent, is able to then draft application and then is authorized by the patent office to represent the client in front of the patent office in terms of the whole patent life cycle. The life cycle of a patent application after the filing would involve the examination of the application at the patent controller or the examiner, who will issue an examination report, which is called as the FER, the first examination report, which needs to be replied back to in 6 months of time, post which the examiner would look at the response and would then issue a hearing notice if he wishes to undertake a hearing with the patent agent on record as to whether the case is actually novel and inventive or not. And therefore, as a patent attorney, you would have to represent the client over a hearing, which is usually done over video conferencing these days, and sort of is taken care of accordingly. Patent agents, as I said, have to be qualified by the patent office, and therefore there are certain bare minimum requirements as regards the age is concerned, as regards the citizenship is concerned, and as regards their technical qualification. Because for you to be qualified as a patent agent, you have to have a technical background. It could be in any domain, but at least a bachelor's has to be there in technical sciences, be BSc physics or PhD in chemistry. Could be as high as that. And therefore, only such authorized patent agents can go ahead and prosecute. Now, there are certain patent agents which have also done their law, which is the bachelor's in law, and then maybe after that even master's in law, and then they are also loosely represented and referred to as patent attorneys. And therefore, that's the difference between a patent attorney and a patent agent, wherein the patent agent essentially is a professional who may not or who does not have a law qualification but has qualified the patent bar, whereas a patent attorney is a person who's done both, who's qualified the patent bar as well as, or the patent exam as they call it, patent agent exam, and has also done law in parallel. And for the prosecution to be done from the filing till the grant of the patent, which is the first phase of career that I mentioned about, you could essentially either be a patent agent or an attorney, both being authorized to essentially represent in front of the patent office. However, if you are a litigator, or if you wish to represent the client in front of IPAB, which is the Intellectual Property Appellate Board, or in front of any of the high courts or district courts in India, such cases would require you to at least have a law background, and therefore you will have to essentially be an attorney. You may not be essentially a patent attorney, which means a patent agent and then an attorney, but you could just be an attorney and represent in the other instances. Patent agents, as I mentioned, typically are professionals who have a strong technical background and therefore are able to understand inventions that are done by various applicants, be it Reliance, be it Larsen and Toubro, be it any other large entity, and are able to then file patent applications based on that, draft and file. And therefore, it is imperative that patent agents have to have a good, strong knowledge, not only of technical know-how or technical understanding in the respective domain of their experience, but also have a strong understanding not only of patent law, but IP system and statutory laws in general, so as to understand how extensions are taken, how are condonation applications filed, and various other aspects that may not literally be mentioned in the Patent Act per se. So as I've mentioned, the following other functions of a patent agent: they'll draft applications. Enforcement of patents would not be done by patent agent per se, but they could assist litigators or litigation or patent attorneys in preparing documentation. They can support them in giving their opinions, and then they also correspond with the patent office regularly for the whole prosecution life cycle of the patent. And other functions could also be conducting patent searches, preparing opinions. As I said, infringement opinions, when a client comes to you and asks you that, okay, here is a product and here is a patent that I believe might be getting infringed. Can you help me confirm that? And therefore, patent agents would then get into their shoes and then render an opinion on whether there is infringement taking place by the product on the respective patent in context. So as we've mentioned, the patent agent is the professional, which is recognition that is offered by the patent office upon clearing an examination, which is called the patent agent. An attorney is an agent who's also admitted to practice law, and a patent attorney therefore does both the functions essentially. I wanted to spend a few minutes on typical attributes of a patent attorney or / agent, whatever we may call it. But before we do this, the topic also had to cover the career in general. I personally, having been in the space for about 17, 18 years now in person, and having founded our own firm, I can with a lot of confidence say that IP is still relatively in its nascent stages in India. It's a fantastic growth opportunity area for various technical domains. And we have seen in the last 13 years, and we are a team of about 200 professionals, and we have seen tons of professionals coming in from premium technical institutes with strong PhD qualifications, as well as the masters in one or more technical areas. And then they contribute by discussing inventions and understanding inventions from various research institutions, as well as inventors or corporates, and try to write strong patent applications because they've done significant work in that particular space. And therefore, as a career opportunity, unless the candidate is very keen to get into the research space itself, wherein they do primary or secondary fundamental research at their own end directly, I think IP is a very, very good career opportunity. In case research per se is not you like research in general, but you don't like getting into the research, or you don't see yourself growing in the research space per se. But by virtue of being in the IP space, you will be able to work very closely with researchers, look at their outputs, and essentially feel very strong about the fact that you're looking at and you're working on technologies that could eventually come 3, 4, 5 years down the lane when technology gets matured. So you can imagine how happy would a patent attorney be when he would have been drafting an application for Serum Institute for the COVID vaccine that they've come up with. And same goes for Bharat Biotech for that matter. It's a matter of pride, and it's also a matter of extreme happiness when you see that the patent applications that you've written and which have been granted eventually in course of time have resulted into actual products which are being sold in the market, are being enforced based on the patents that you have, and are being commercialized, licensed, and sold and transacted upon on a daily basis. So I think that's the main spirit and what keeps us going as regards motivation is concerned. Now, based on what I spoke about, I think there are certain aspects that come quite naturally in terms of what would the typical attributes of a patent attorney be. Now, any patent attorney is expected to obviously be very good at reading various technical documents. And when I say technical documents, I don't only mean patents or which are US or European or Indian patent applications, but also research articles, white papers, and basically read them, understand them, interpret them, and also try to correlate how a portion of the document can essentially be used in some kind of a proceeding, be it an invalidation search that you may be doing to invalidate a granted patent, or maybe a patentability search to confirm the patentability. Because as I said, there is not just one test of novelty, but there is also a test of inventive step, where the whole assessment is that in view of certain documents, is my invention inventive? Is it that it is not obvious to somebody who's skilled in that particular art, or has ordinary skill in that particular art? And therefore, as a patent agent / attorney, it is imperative for you to be able to understand technical documents in as much more depth as is concerned, and identify and isolate and retrieve specific portions that can be used depending on the purpose for which you have located those documents. Now, you would also see that in the Indian ecosystem, IP is not just limited to law firms. There are many KPOs and other consulting firms that could not necessarily get into the patent drafting or prosecution or litigation space. There are numerous firms in India that are big and also focus, for example, on analytics, or on searches, or on outsourced patent practice, where bulk of their work essentially would be to, for example, do patent searching on trying to invalidate patents, or novelty searches, or invalidation searches, or freedom to operate searches, and then they go on also to do landscape and analytics, where large companies like Johnson & Johnson, for example, may require, they might want to understand that in the medical device space, and in a particular medical device, what are the kind of companies that are filing patents? When are they filing it? How are they filing it? What are they claiming? And what is the kind of research work that they're essentially doing is also reflective in the patents that other companies file. So this is also called as competitive intelligence or analytics, where the interest of your client would be to understand what their competitors are doing, so that they can align themselves as regards their research strategy is concerned. And therefore, there is a whole new classification of patent professionals that may not be patent agents, may not be patent attorneys, may not even be doing litigation, but are essentially called as patent engineers, who would have technical background, and therefore would essentially, their work would essentially evolve around doing all sorts of searches, analytics, and going ahead and rendering results out of the research that they've essentially done. So any such kind of work always requires you to have a very clear and open mind in terms of how a document can help me to define or render this to be invalid, or render this to be valid or novel. And therefore, depending on the scope and the mandate of the search, the professionals would have to act accordingly. So the first is to understand, being able to understand different technologies, because certain colleagues in the firm come from very specific area of microbiology, but you may not always at every point in time have clients that are from that particular space, and therefore they might be clients that are from plant side of it. There may be clients who are from biotechnology side of it, and therefore, even though you might come and have a specialization in a particular domain, it's very important and imperative that you are open from a mindset standpoint to do and handle other technology areas as well. So because I come from, for example, a patent background, from a computer science background or a software background, but for the last 18 years, I've been writing enough number of applications in the space of electronics and even mechanical. Of course, not pharmaceutical and chemistry per se, but then even within computer science, there are encryption technologies, there are encoding mechanisms, there are tons of other technology areas that you then end up focusing on. And therefore, it's very important to have your mindset very open as to what the technology is. Even if you don't understand it in the first go, Google is out there, and you can, I'm sure, spend a few hours, see a few videos, and then you will get a better handle of the technology. Inventors are more than helpful at all points in time to explain what their invention is, and sometimes they are happy to even take back and teach you what led to the invention. And therefore, there is always every kind of help that is available out there. It's just a matter of mindset that you have to be open, as because if you are very close, then your growth levels will become difficult for you to obtain. And therefore, have a very open mindset on technology, be open to read various documents on the technology, white papers, research articles, and then also communicate very strongly, because I think it's not just a matter of communicating with clients and inventors, but as a patent agent, one of your most important responsibilities is to communicate with the examiners, who are also called as controllers at the patent office, because they're technical people, and when they call you for a hearing, you only get that 20 to 30 minute space to essentially try and justify the whole case out. And if you don't communicate effectively, you will surely not be able to obtain the patent very easily, because you have to be able to explain what the invention is, be able to explain what led to the invention, what are the disadvantages in the prior art, and therefore communication and confidence. A lot of people also in front of judges or in front of controllers become a little uncomfortable, and therefore even though they're very strong technically or they know everything, they're not able to communicate it as confidently. That also sometimes leads to an impression in front of the controller that probably he's not very clear with what the invention is, and may lead to refusal of a patent application. And therefore communicator is very important, followed also by interpersonal skills, which I think is a bare minimum requirement for every industry vertical as well as career opportunity at this moment. Because you have to speak with inventors. There is a specific level and mindset with which you have to speak with them. You have to respect their invention. Even if it is not patentable, there is a way you communicate it out. You have to be soft. And on the other side, even with the patent office, and on the other side, even with the tribunals, and also with the judges, and various other stakeholders, including clients and legal counsels and IP counsels. You have to be polite, you have to be courteous, you have to be sensible in terms of being able to communicate, but that message being sent across to the other side is imperative, because that is extremely important for communication to take place. Now, strong understanding of patent laws and CPC in general, I have emphasized on this earlier as well. It's important to have a strong understanding of the Patents Act 1970. It's not just about drafting of patent applications, because if you're just drafting and you don't do prosecution, which is what a lot of professionals also get into, where they have 10 years of patent drafting, but they have never done a hearing with the patent office, or never have prepared a response to an examination report. Or there are patent searching professionals who have never done drafting or litigation or prosecution. They would definitely have a hard time in communicating about certain provisions of, say, Section 18 or Section 33 or foreign filing license, or via Form 1 requires what kind of signatures, compliance of Form 3, apart from others. So I think as a patent professional, it's extremely important that you intend to grow vertically as well as horizontally in your space, and not get restricted only to one type of work. Because then if you do that kind of work for 3 or 4 years, then you would largely get typecasted in that particular space, that you're only doing patent searching, and therefore searching is what your focus would tend to be. And therefore you should, to the best of your abilities, talk to your colleagues, super colleagues, and try to take more assignments in other areas, like for drafting or for responses or for opinions or for litigation, and demonstrate yourself. I think it's very important to have that intent. Because if you were given a patent application for drafting and you have not done a good job, it is hardly a case where you would get a second opportunity. So it's not just about asking for opportunities, but also making sure that when you get one, you do justice to it, and you are very serious about it, and that you spend enough time in doing research by reading other applications. Because as a patent professional, there is no limit to the learning, right? You can grow as much as you possibly can. There is always evolvement of law. There are always new cases coming in. There are always new practices of drafting coming in. Every few years, there is a breakthrough case that comes that changes the whole way you practice in opposition matters, or in drafting matters, or in prosecution, or even for searching. The way we used to search 10 years back is completely different from the way the searching team at our firm works now. The way we generate reports, the way we analyze documents, all of that, there's absolutely no dearth or limit to it. This is just a posting of what kind of prerequisites there are to become a patent agent in India. You have to be an Indian citizen, greater than 21 years, have a science background, and you have to qualify that particular exam. And this is what essentially I thought I would mainly focus on for today. I think it's a fantastic career opportunity. It's a very, very initial stage in which Indian companies are now taking it seriously, with new cases between Britannia's and Nestle's and Reliances of the world, and tons of IP activity going on in India. And I think India is on the same spree and vertical as China was about 7, 8, 9 years back. And therefore, the way China exploded to become the number one country in the world from a filing perspective, the way Huawei, who is a client of ours, has been filing applications world over as one of the highest patent filers. I think India is also realizing that it is not just enough to be a strong manufacturer in terms of quality, but also for you to be differentiated. It's imperative, because IP is the only thing that a company can differentiate itself with respect to the other company. Anything else in terms of a fantastic machine that you may have will at some point or the other get copied if there is no IP over it. And therefore IP has to be taken up seriously, and by virtue of that, in the next 10, 15 years, we surely see IP as a vertical growing significantly, and patents as a very, very core component of all of these IP verticals, be it in the telecom domain, be it in the telecom services domain, be it in engineering space. Numbers are fantastic, and India is growing by 20 to 30%. And therefore, I think it's for professionals who are good at writing, who are creative at writing, who like to talk to inventors or people from the government offices, and who believe that they will be happy to read as much literature as is given to them. I think it's a right fit for them as regards the vertical is concerned. So this is my mandate for today, and very happy to take up questions and any comments or feedback that might be there.
Thank you very much, sir. It was really an interesting conversation. So we have some questions which I will moderate to you. So my first question is, India is actually India has a rich heritage of knowledge, right? But many of the systems or methods in it which have been used since ancient India have not been patented. So what is your take on that? Will patenting improve knowledge economy in India, or
no? I think I'm a fundamental believer that if patents or IP in general were not there, what was the incentive for somebody to even go ahead and do innovation? Why would he spend thousands of dollars, or company like Serum, for example? Why would they even spend, God knows how many crores they would have spent in the last 6, 7 months to develop and come up with a vaccine? The only motivation to do it is that when I come up with a product, or when I come up with a vaccine in general, I'm able to at least stop anybody else from doing or making that. Because if I invest so much of money and then eventually there is no IP with me, and then everybody ends up making it, then I will never be able to recoup or retrieve the kind of investment that I've made. So IP therefore becomes very important, an imperative part in today's vertical, particularly when companies have to differentiate themselves. Otherwise, you will never be able to grow, and there will be no motivation for you to innovate. Some people may do it as a part of habit, but 90% of the people do innovation essentially so as to be able to monetize that invention or innovation at some point in time. Obviously, there was a big cultural change that was there hundreds of years back, when people obviously wanted to do it for dissemination at large, and commercial benefits were not the intent. But in today's world, surely it has to be everything has to be looked upon from a commercial standpoint.
Okay, thank you so much. So my next question is, like in universities, still publications are more popular than patents, right? So students or even professors, they prefer publications as a first thing compared to patents. So how do we change this scenario, or is it even important to change?
No, I think it is already changing, being very honest. Obviously, when we started the practice about 10 years or 12 years back, that was the case. But I think if you look at it now, we represent many IITs from Delhi to Roorkee to IISc Bangalore to many other top institutes. I think there's a very heavy dissemination and clear understanding in front of the researchers and innovators in those research institutes, that they have to go ahead and file for patents and get IPs as well. In fact, a lot of institutes have also been given mandates by education ministries and also various departments thereof, that they will get incentivized by filing patents, and they have to show what kind of IPs they have, registered versus unregistered. Everything has to be documented. So I personally don't think that professors in top tier colleges particularly would prefer to do white papers over patent. They might do white papers as well, but I don't think they would prefer that in today's time because of the cognizance they have. I think they give equal preference or equal treatment to patents as well, and that preference is going to surely increase in time to come. It's not that the publication would come down, but people surely understand that they have to file for patents before they publish any material, and therefore they'll do the patenting first and then go ahead and do the publication thereafter. And I think that is a clear fact with most of the top tier colleges.
Okay. My next question is, what is the remuneration for patent agents, and how much of experience should one gain to reach a good position?
So remuneration, there's no standard per se. However, if you start with if you're a PhD or if you're a master's, then you start your career, you're maybe looking at around 8 to 10 lakh rupees, I would say, to start with. And then as you sort of grow, you could probably in about 4 years or 3.5 to 4 years reach about 20. And then post 20 is always a factor, not just of how good a patent attorney you are, but also a factor of how good in terms of your overall business acumen are you. Because when you're about 5 or 6 years of age, and then if you've been able to do very well to be able to reach around 20 to 25 lakh rupees in annum as a package, the intent of the organization in general is also that the contribution is not just on operations, but also on strategy of the firm, business development activities, and therefore how good you are on those aspects would govern your further growth thereafter. But even 40-50 lakh rupees an annum is not that hard to achieve after 10 to 12 years of experience.
Yeah, thank you, sir. So the next question is, can you please comment on intellectual property rights for algorithms in India?
So I did touch upon it with respect to Section 3K of the Patents Act, where if the algorithms that you've developed, or if the software mechanism that you've developed is solving a technical problem. Now, for example, if it's reducing the memory latency, or if it's having a technical character to the whole invention in terms of processor time getting down, or processor speed going up, or encryption of data protection, data being better protected, security algorithms, data packets being processed in a manner so that they're more secured. All of these are technical issues, and therefore any algorithm to implement these would be patentable. However, if you have an algorithm that serves a functional purpose, like for example, if it's profiling the users better, or if it's helping you book your ticket from here to Srinagar, for example, or if it's solving a functional problem, even if it's an improvement, even if the algorithm results in a functional improvement, it will be very hard to obtain a patent under Section 3K. But if you can correlate your technical improvement or the algorithm to a technical problem that it is solving from a computational standpoint, that okay, here was a problem which was existing in terms of data transmission or packet transmission or encryption. While encryption, there were certain bits that were not required. So if you're basically solving a core technical issue, or if your algorithm has a tie-up with a embedded machine, for example, if you have an X-ray machine in which the algorithm is embedded, and if it is able to do certain things that enable better scanning to take place, surely would be a good case for obtaining a patent.
Cool. So the next question is, when we submit some information to the patent office for patenting or any kind of like protection, how is the confidentiality of information maintained?
So the patent office obviously keeps everything secured for 18 months, unless you file for a request for early publication. The publication happens after 18 months, and everything is electronic. I have, in the last whatever number of years of experience that I carry, I've never seen an incident where the patent office database was hacked and certain materials was extracted. Because if after filing, even if there is a hack or some publication that happens, it is not a problem because you've already filed and you have a date protected. The trouble is only when something gets into the public domain before the filing, which obviously would never be a problem of the patent office. So I think the more appropriate concern would be of how you manage the data within yourself, how you manage your inventions and keep it secure enough to be able to apportion your confidentiality accordingly.
Okay. Yeah, if a product is patented in one country, how do we go for patenting rights in another country?
So as I had mentioned again in the earlier topic as well, in the earlier discussion, that you can file a PCT application, which is called the Patent Cooperation Treaty. You can file an application in India file the PCT within 12 months, and then PCT will give you 30 months from the Indian filing date to file the application world over in US, China, Japan. Every country has their own filing fees, has their own examination procedure, and therefore the grant will happen independently in every country. That is one way. That is the PCT route. And the other route is a Paris Convention route, where once you file it in India, you get 12 months again. Instead of filing a PCT, you can directly file your patent application in US and China, Canada, wherever we wish to.
Yeah. So can you please comment on like the morality aspects and ethics of patenting? Because there are different disciplines of patenting. For example, some kind of food technology or health technology. Is it appropriate to patent it and commercialize it? And how do we ensure that patenting rights go to the right people?
So I think morality and ethics can always be controlled through regulations and procedures and petitions and court orders and grievances, etc. There are various mechanisms and various departments and various judicial forums on which you can always file a writ petition, for example, to state that there is a monopoly being granted to him and he's not selling it. But those questions will only come when the patentee is actually not either commercializing it himself and keeping it and not giving it to anybody else, or he's commercializing it but selling it at a very high price value, or essentially is selling it at a high price value but is not able to make appropriate volumes for the whole consumption to be done in the appropriate time. That is, it is not available to the public at large in the right quantity, and other issues of that nature. Only these are circumstances when morality would even play a role. Otherwise, if the company is sort of doing the best it can, is keeping the right price points, expecting that the company would sell it for free or would sell it for less than the apportioned amount, would not be reasonable at all. Because if serum, the vaccine comes at whatever 100 rupees or 200 rupees, that price point has been kept at a very, very conservative level, keeping in mind the investment that has gone into coming up with the vaccine as well as to manufacture it. And therefore, if somebody can challenge to say that, okay, it is being made for 2 rupees, but you're selling it for 200, is only when the question of morality would even come in. Till which time, I don't think it's a concern. And when this issue comes in, there are various forums. There's Section 84 in Indian Patent Act to have compulsory license. Any party can apply for it. There are government powers that government can take a mandatory license from the patentee to say that you have to give it to these parties or you have to give it to us. You can file a writ petition. You can go to the Competition Council of India and file a complaint that their practices are anti-competitive, etc., etc. There are all sorts of it. So I think I personally don't see it as a big problem, particularly in the context of Indian scenario where most companies are conservative and don't really become very offensive on trying to gain and have a monopoly.
Okay. Yeah. Can you please comment on preparation for exams or to become a patent agent? How much of effort does it take? And
when there's effort in life that has to be done, and everybody has to put efforts for whatever they do. In terms of number of hours, I would say there is a particular plan because we do a few training courses ourselves as well, and therefore there is a certain structured way by means of which if you go, I think about a month is good enough for you to sort of do it, but you'll have to spend 3-4 hours every day and be very consistent in terms of your understanding, be very open in terms of asking questions to yourself and to Google and do research so that you don't mug it up like an actor per se, but you actually understand the fundamentals of it and what led to the act. And then that understanding of legislative intent is very, very, very important. And therefore, I think about a month is enough. 2 months is fantastic, but it again depends on how much time you spend the whole day. But 3 to 4 hours a day, about a month, I would say. And then if you go in a structured way, if you cover up certain sections and portions on a daily basis, I think you'll be good to go.
So will this certification or exam requirement vary from country to country, or is it possible for Indians to go and work abroad as a patent agent?
So I mean, every country is territorial, as I said, every IP is territorial. Therefore, Indian patent agents can't obviously practice as a patent agent in the US. So US has its own exam, India has its own exam, and therefore they will have to sort of pass both the bars if they wish to. And for you to qualify at the US patent bar, you have to work with a US firm or intern with that firm for a little while. So there are specific rules in terms of citizenship, people who are not citizens, how much of residency they have to show. So there is a whole chapter of requirements that would have to be complied to, post which only you will be able to qualify the US patent bar and become.
Okay. So I will ask one more question because you had mentioned like 250 was your stop
Sure.
point.
Sure.
So yeah, like apart from novelty, what are the other criteria for patenting, and how to relate it with the quality of patents?
I think that's a whole new topic in general. Quality of patents to me is can be objectively understood if you understand how the patent's been written, how the claims have been written, how narrow the claims are, how broad the claims are. So the longer the claim, the narrower the claim it is, and therefore it is not reflective of a good draft. But if it's a broad claim, if with very few elements or limitations, as we call it, then obviously the character of the invention sort of comes out from there. But the manner in which those claims are supported in the description, the manner in which the drawings are supported, is the disclosure full and complete and sufficient or not? There are numerous parameters based on which a quality of a patent application is determined, and that is what separates a good patent drafter from somebody who's average and somebody who's not good at all. So I think it's not that difficult for to read a patent application, because all of them are in public domain. You can read, analyze, look at how well they've written, in not only in terms of English but in terms of legal character. How many embodiments have they written? How many alternate embodiments have they written? What did you give them as input as far as the invention disclosure is concerned, and what they gave you as the patent draft? Because if the output is largely the same as input, it means that the patent attorney did not add much value. But if the patent attorney understood the invention, closed your document, and then exploded that patent application to cover not only your invention but various other possible variations or modifications thereof, surely you can get the patent there. You can sort of treat it to be a good patent application.
Yeah, I'm sorry, sir. This is a follow-up question of whatever you mentioned right now. So, yeah, in journals we have like ranks of journals. We can measure the quality of journal publications using an impact factor. So, how does a student understand like this is a good patent and this is not? Is there any hierarchical system right now?
Not really. Being very honest, it's a matter of if the student is not aware of how patents are written, he will never be able to evaluate. So for a student to be able to evaluate, he will have to understand how patents are written and read hundreds of applications to be able to understand, okay, this is the way you legally represent a technical invention. That if that understanding is not there, no review would get justice.
Okay. Yeah. So thank you very much, sir, for spending your time with us today and sharing valuable insights about patenting. So I'm sure it has inspired many of them. So most of the questions were asked from the chat, except a few which are from the committee. So I would really like to thank you again for joining with us today, and on behalf of management of Research Scholars Day team as well. So yeah, would be happy to connect with you in a suitable opportunity again sometime. Thanks again.
Thank you very much, Vamika. It was a pleasure, and thanks for having me here. Thank you, sir.